Dear Madam Minister, dear Mr. President of the Kúria, right honorable judges, distinguished colleagues, ladies and gentlemen. For the rule of law, in the sense of the German Basic Law, the submission of all public authority to the law and the review of this legal obligation by independent courts are essential. The independence of judges, together with the judges' monopoly of the exercise of judicial power, forms the institutional core of the constitutional principle Rechtsstaat, and thus an indispensable component of the constitutional order of the German Basic Law and of its separation of powers principle. Judicial independence requires judges to be free from instructions. In particular, the German Constitution prohibits any influence by the executive on the manner in which the judiciary performs its duties, whether through individual instructions, administrative regulations, or otherwise. This is intended to ensure that judges make their decisions in full compliance with the law. The question arises whether the principle of judicial independence has also so-called preliminary effects on the appointment or election of judges, i.e. the manner in which judges take office. Do judges themselves have to be granted decisive influence on the appointment or election of judges? Before answering this question, I shall first outline the different ways in which judges are appointed in Germany. Judges are entrusted with the independent administration of justice, subject only to law. The manner in which judges are appointed or elected is one of the basic problems of a democratic constitutional order based on the rule of law. It can be regulated differently, but not arbitrarily. The mode of appointment for judges is not uniform in German, but varies between different jurisdictions, i.e. between the federal government and state governments, and also from state to state. In principle, the state governments, Regierungen der Länder, have sovereignty over the appointment of state judges, Richter der Länder. The appointing authority is therefore the state government itself or a supreme state authority designated and authorized by the state government. The selection procedures are regulated differently in the various states. In some cases, the selection procedures are carried out by the supreme state courts. In other cases, for example, the selection is carried out jointly by the Ministry of Justice, the higher regional court, and the Office of the Attorney General. Under Article 98, Section 4 of the German Basic Law, the states may determine that the appointment of judges is to be decided by the State Minister of Justice together with the Judicial Selection Committee. A number of states, not all, have made use of this option. Members of the judicial selection committees are usually members of the respective state parliaments, as well as representatives of certain professions, especially judges, but also lawyers, university professors, and other persons. In some cases, members of the executive are also represented. The election of members of the judges' election committees is regulated differently in the various states. In some states, the members who do not have the status of members of parliament are proposed by the respective professional group and must subsequently be confirmed by the parliament. In other states, the professional members are elected without confirmation by the parliament. The judicial selection committees, that is important, may not have sole or final decision-making powers. Appointment of judges on the state's level without the consent of the respective Minister of Justice is unconstitutional. It can therefore be stated that the executive branch always plays a decisive role in the appointment of state judges. The selection decision itself is determined by the principle of selection of the best. Special features apply to the judges of the state constitutional courts. They are elected by the state parliaments. Ladies and gentlemen, other regulations apply at the federal level. Pursuant to Article 95, Section 2 of the German Basic Law, the appointment of judges to the Supreme Federal Courts is decided by the federal minister responsible for the relevant subject area, together with a judicial selection committee. The Judges Selection Committee consists of the ministers of the states responsible for the respective subject area and an equal number of members elected by the Bundestag, the German parliament, for the respective legislative period. Only the competent federal minister and the members of the Judicial Selection Committee have the right to propose candidates for election as federal judges. In preparation for the selection decision to be made by the Judicial Selection Committee, the Presidential Council of the Federal Court, to which the judge is to be appointed, shall issue a written opinion on the personal and professional suitability of the candidates, which shall, however, not be binding for the committee. The Judicial Selection Committee then examines whether the person proposed for a judicial office has the material and personal qualifications for that office, and then decides by secret ballot with a majority of the votes cast. After the election, the competent federal minister must independently verify whether the nominee meets the substantive and personal requirements and then request the appointment of the judge by the federal president, dem Bundespräsidenten, who finally carries it out. As far as the Federal Constitutional Court is concerned, half of the members are elected by the Bundestag and half by the Bundesrat, which is the representation of the various states, Länder, at the federal level. For this purpose, the so-called Bundesverfassungsgerichtsgesetz, a specialized federal law, prescribes the requirement of a majority of 2/3 of the votes, at least the majority of the votes of the members of the Bundestag, and of 2/3 of the votes of the Bundesrat. The Bundestag shall make its decision on the basis of a proposal by the election committee composed of members of the Bundestag. That is my overview. Now, what about the determining influence of the executive or legislative power on the appointment or election of judges? According to the quite prevailing opinion of German constitutional law scholars, the determining influence that the executive or legislative branch has on the process of appointing or electing judges is unproblematic with regard to the guarantee of judges' independence and, moreover, is democratically imperative. it does not follow from the guarantee of judges' independence in office that the appointment of judges must be removed from the power of political determination, and that the body responsible for the selection must therefore be politically independent. The executive's branch commitment to the principle of selection of the best excludes an arbitrary selection by the executive. Democratically, the executive's branch's right to decide or the legislature's right to elect is an imperative. Judges exercise state power. State power must be sufficiently democratically legitimized in terms of personal and substance. In terms of substance, legitimacy is derived from the laws enacted by Parliament to which the judges are bound. In terms of personal, democratic legitimacy can only come from an appointment by an at least indirectly democratically legitimized body or official, such as the responsible minister, or from an election by the directly democratically legitimized legislative body. A unilateral appointment of judges by the judiciary itself, without authorization by a democratically legitimized body, would lack the necessary democratic legitimation and would represent a form of judicial oligarchy in which admission to the judiciary would take on the character of cooptation of the judicial core. The direct election of judges by the Parliament resulting from elections increases democratic legitimacy. It is therefore the procedure put in place in Germany for the election of judges of the Supreme Federal Courts who are granted the competence to develop the law and thus in effect a complementary legislative competence, albeit limited, as well as for the judges of the constitutional courts who are assigned the interpretation and further development of constitutional law and thus a highly political function as a constitutional body. The criticism sometimes leveled at the standard mode of appointment by the executive is misguided. There is no room under constitutional law for the independent self-administration of the judiciary, including in the appointment of judges. The constitutional principle of separation of powers, which in any case is not a principle of strict separation of powers and does not say anything about how judges to whom the judicial power is entrusted get into office, does not demand it. The participation, there is no autonomy of the separated powers for their own staffing. The participation of judges in the appointment of judges is therefore not a legally necessary consequence of the principle of separation of powers. On the contrary, the democratic principle of the German Basic Law excludes a genuine right of co-decision by the judiciary. This misguided criticism has nevertheless been taken up in European institutions. For example, it was included in the recommendations of the Committee of Ministers of the Council of Europe in 2010. However, like other opinions of other institutions and non-governmental organizations, they are not binding law. Therefore, taking into account that there are different systems for the selection and appointment of judges and no uniform regulation in all European states or even uniform standards, the European Court of Human Rights has correctly decided that the appointment of judges by the executive or legislative is in principle permissible under the European Convention on Human Rights. provided that the appointees are free from influence or pressure in the exercise of the judicial office. However, the court coupled this statement, this true statement, with a sibylline remark that it applies even though the separation of powers between the political organs of government and the judiciary has become increasingly important in the administration of justice. End of quote. This sounds as if an appointment by the executive branch alone might seem deficient in terms of separation of power. However, this is not the case, as has been shown. In line with the European Court of Human Rights case law, the European Court of Justice in Luxembourg has also ruled that the mere fact that judges are appointed by the President of the Republic cannot by itself create a dependency of those judges or cast doubt on their impartiality. If once appointed, they are not subject to any pressure and are not subject to any instructions in the exercise of their office. And that therefore corresponding arrangements of the appointment procedure in and of themselves are compatible with the principles arising from Article 47, Section 2 of the European Charter of Fundamental Rights. However, according to the rulings of the European Court of Justice, something else may apply if the same circumstance, in conjunction with other relevant aspects and the conditions under which these decisions were made, gives rise to such doubts. I come to a conclusion. It is to be welcomed that the European Court of Human Rights and the European Court of Justice recognize in principle the appointment of judges by the executive as being in conformity with the Convention and Union law. Any other assessment would not only provoke a conflict with Germany, which touches on its constitutional identity with the principle of democracy, in which Germany simply cannot back down, but would also have to call into question the legitimacy of the European Court of Human Rights and the European Court of Justice as independent courts themselves. That is because the judges of the European Court of Human Rights are elected by the Parliamentary Assembly of the Council of Europe for each convention state by a majority of the votes cast from a list of 3 candidates proposed by its government. And the judges of the European Court of Justice are appointed by the governments of the EU member states by mutual agreement. Therefore, ladies and gentlemen, as much as the independence of judges as a cornerstone of the rule of law requires effective protection and vigilant guardians, demands such as those of the Venice Commission to place the appointment of judges largely in the hands of the judges themselves should not be yielded to. Such professional judicial power would not be associated with added value for the rule of law, but with authoritarian corporatism from which democracy would suffer. The power of judges over judges places far narrower limits on judicial independence than the steering capabilities of the ministerial bureaucracy. The dispute over the mode of appointment of judges and the imperative demand for a right of co-decision by the judiciary itself is a struggle over the key position of personal sovereignty over judges in judicial policy. The influential representatives of the judiciary itself dispute the rights of both the democratically legitimized executive and the legislative. But the idea of self-supplementation of the judiciary is in danger of creating a caste uncontrolled in all directions. On this issue, for the sake of democracy, there must be no yielding. Notwithstanding this, the constitutional guarantee of judicial independence remains unaffected and intact. Thank you for your